The decision of the combined UK Supreme Court and Judicial Committee of the Privy Council in the Crown against Jogee and Ruddock against the Queen is an important decision for criminal justice. The decision concerned complicity, the area of criminal law for those who did not actually commit the crime, but who assist or encourage another to do so. At stake was how culpable you have to be liable as an accomplice. For centuries, English law had required that the accomplice intend to assist the principal, believing or intending the principal would commit that crime. That changed in 1984, when the Privy Council suggested that an accomplice need only foresee that the principal might commit the crime. That is, that such foresight was not just evidence of the accomplice's intention that the principal commit the crime, but that foresight was sufficient as a standard of fault itself. That decision of the Privy Council was what was corrected in Jogee and Ruddock. Once again, an accomplice must intend the principal to commit the crime. After over 30 years of this rule, there will need to be some corrections to current prosecutorial practice and potentially some reassessment of some existing convictions. Difficult decisions on facts will certainly be necessary in Jogee and Ruddock's cases themselves, but the facts of those cases are not what actually concern us now. For the moment, let's focus on 3 points. First, what does the law of complicity do? Second, what did this case do and why? And third, what will the impact of the case be? So first, what does the law of complicity do? For centuries, the criminal law has prohibited not just committing crime, but also assisting or encouraging another to commit crime. It does this in various ways. First, agreeing with another to commit a crime is itself the crime of conspiracy, and for centuries, encouraging another to commit a crime was itself the crime of incitement. For those, which we call inchoate or incomplete crimes, because the full crime has not yet come about, we name them in a particular way. But second, and more importantly for present purposes, where the full crime has taken place, a person who assists or encourages it can be liable as an accomplice. In English law, if you're an accomplice, you can be charged, convicted, and punished as if you were the principal, the person who actually committed the crime. That means that if 5 people attack a victim, preventing his escape, intending a 6th to kill with a knife, the law can convict 6 murderers with 6 mandatory life sentences and significant minimum tariffs in prison. If you pause for a moment, you will realize that there are many people who are serving life sentences in prison who did not, by their own acts, kill. The reason for this rule is not that we think accomplices are automatically and always responsible and culpable, just as if they were the principal, and the tariff they receive in prison can reflect that. Rather, the rule is to deal with what happens when we do not know which of 2 or more defendants were involved in a crime. We know that much, but we don't know which actually committed it and which assisted. The law attempts to solve this by treating them all as principals, rather than requiring that all be acquitted. The physical acts of complicity can take 2 forms. 1, you assist. You provide physical aid to the principal to commit the crime, like a weapon, information, or acting as a lookout. This contribution can be very small, such as being one of a number of people who gave the same information or offered the same weapon. 2, you encourage. You support, lend courage, or tell someone to commit a crime. Under the Privy Council case in 1984, called Chang Wing-Siu, there was one other twist. That case seemed to create a special form of complicity, for where you agree to one crime and another crime comes out of it. 2 rules made it easier to convict there. First, the law didn't ask for you to have a clear contribution to the second crime. And second, the accomplice was no longer required to intend that the principal commit the second crime. The accomplice merely had to foresee the chance that the principal might commit it. From there, the test of mere foresight of a possibility ended up being used in normal complicity cases, not just ones with multiple crimes arising from a first. We call this special form of liability parasitic, in that the defendant was being made liable for a second crime, parasitically on the first. You may have heard the phrase joint enterprise. It's a word put together to describe criminals acting together, but it is not a technical legal term. The trouble is the phrase can cover 3 very different situations with different problems and different rules. It can cover simple complicity, the extended form, parasitic, such as in Chang Wing-Siu, and even where one principal is acting together with another, making them co-principals, if you will. It's best to avoid the word or term joint enterprise, which is what the Supreme Court did and has done for some years. Second, what did this case do and why? The decision in the combined case of Jogee and Ruddock undid the change in Chang Wing-Siew. Thus, 1. English law now rejects the use of foresight as a test of substance. The accomplice is liable if he intended to assist the principal to commit the crime, but what the accomplice foresaw might be evidence from which the jury can infer intention. And 2. There is no longer any extra form of complicity where one crime is parasitic on another. Putting that in context, let's take a case of murder. First, to be liable for murder, the principal must kill, intending to kill, or intending to cause serious bodily harm. Note immediately that in English law, you can be a murderer when you positively did not want to kill. If you intend to break someone's arm, and only break someone's arm, and for some reason the victim dies, then you are liable for murder. To be an accomplice to murder, the law under Chang Wing-Siew was that you needed to deliberately assist the principal, foreseeing the possibility that he might kill or cause serious harm. Notice that that standard of fault was a lot lower than that the principal had. Why should it be easier to convict as an accomplice rather than as a principal? Didn't make sense. Under the law now, an accomplice would need to intend that the principal commit the crime. Evidence that the accomplice foresaw that the crime might happen and then assisted or encouraged would be evidence for the jury to consider in deciding whether the accomplice intended the crime. If the accomplice did not so intend, he cannot be liable for murder. But most importantly, he could be liable for another crime, and in particular, a crime still connected to the death that happened. If the accomplice assisted the principal to commit a crime, in circumstances which a reasonable person would say were dangerous, and death resulted, the accomplice would be liable for manslaughter. A manslaughter conviction would still reflect any responsibility and culpability the accomplice had for the death, but does not suggest that the accomplice was a murderer or equivalent to a murderer. In rare cases, the death might happen through some overwhelming supervening act by the principal, which no one in the defendant's shoes could have contemplated, and which relegated the accomplice's contribution to the historical background. In such cases, the accomplice is not liable for the death at all, though may be liable for other crimes based on the same events. Why did the court decide as it did? Well, put simply, Chang Wing-Siew had been against the previous cases, and the court said so. In this, they were clearly right. The Chang Wing-Siew decision erroneously elevated a rule of evidence into a rule of law, and it's hard to say precisely why they did so. Academic explanations have included the idea that once you have agreed to one crime, you've changed your normative position, and it should be easier to convict you of further crimes. One might agree with that, or one might not. Turns out the court didn't. Some of the issues are also about evidence. It might be hard to prove what a defendant intended, but it might be easier to get a jury to decide that the defendant must have foreseen something. The court decided that these reasons were not good enough for the rule, and in particular they highlighted 4 reasons why that rule should be replaced. First, well, the court had had a lot of benefit drawn from a fuller analysis from previous decisions preceding Chang Wing-Siew, and so they could clearly point to the problem that Chang Wing-Siew created. Second, the law had not been working well. It was highly controversial and gave rise to a very large number of appeals. Third, it was strange that the law had allowed an accomplice to be convicted more easily than a principal. And fourth, as a core doctrine of the criminal law, complicity needed to work properly. If the courts unduly widened it in 1984, the courts should correct that error. And in addition, they were doing so in a way in line with recent legislation. The Serious Crime Act 2007 had dealt with inchoate liability, that is, where the full crime hadn't happened yet, for assisting or encouraging another to commit a crime. That act requires that the defendant assist or encourage another intending or believing that the other will commit the crime, not merely foreseeing that the other might commit it. Third, what will the impact of the case be? Well, aside from the individual appellants, this decision could affect many others who have been convicted as accomplices. Since Ruddock was a Privy Council decision, the impact could be felt around the world, in all countries which still use the common law as set out in Chang Wing-Siew. However, the Supreme Court was very clear that the effect of putting the law right is not to render invalid all convictions which were arrived at over many years, faithfully applying the law as laid down in Chang Wing-Siew, and later decisions of English courts relying on it. Well, first, in practice, very many prosecutions of multi-defendant cases are based on the defendants being in it together. That is, intending the crime to take place, rather than merely foreseeing what another might do. If a jury convicted on that basis, then Jogee does not affect the conviction. Second, where foresight was plausibly why the jury chose to convict, it might be possible for the defendant to have the case examined again, to see whether a retrial or a substitution of a different conviction or an acquittal were appropriate. If the defendant was recently convicted and within the time limit for an appeal, that is possible, that reassessment, at once. However, English law has a very clear rule which, as the Supreme Court said, where a conviction has been arrived at by faithfully applying the law as it stood at the time, it can be set aside only by seeking exceptional leave to appeal to the Court of Appeal out of a time. That court has power to grant such leave and may do so if substantial injustice be demonstrated, but it will not do so simply because the law has been applied. The law applied has been declared to be mistaken. Thus, correcting the test for culpability and complicity is there for the future and for the past, but its effect in the past will only be to correct cases of substantial injustice, not to undo every case. That injustice will be more likely to be the case where the defendant was at the edge of events and only convicted because the jury thought he must have foreseen what might happen rather than the accomplice actually intended it to happen. We might pause here to consider one example which seems to have attracted a lot of media attention. It's often claimed that the conviction of two people in connection with the murder of Stephen Lawrence, this is the Crown against Dobson and Norris, was an example of the joint enterprise doctrine, so-called. This perception might resonate with the public, encouraging their support for this doctrine, particularly given how abhorrent the killing and how long this step towards justice took. However, the sentencing remarks of the trial judge, Mr. Justice Tracy, suggest that the case against Dobson and Norris did not rely on a test of foresight at all. Mr. Justice Tracy did not use joint enterprise or a cognate term. He sentenced on the basis of findings that the defendants, well, first, by force, kept the victim on the ground while he was stabbed a second time, and second, the defendants had an awareness, acceptance of, and approval of the use of a knife on another in a deliberate, concerted attack aiming knife blows at vulnerable parts of the body, and which caused death in around 10 seconds. He added that none of the group did something that no one else expected or approved of. Now, if the sentencing remarks reflect the jury's view, the defendants had not merely foreseen serious injury, they had intended it. Jogee should not affect jury decisions based on intention. If someone successfully appeals their conviction because of this judgment, they will, by definition, not be murderers in the eyes of the criminal law. Their murder conviction was an error. They might instead have been convicted of manslaughter for their role in the death, and then they served their time. Or they could have been imprisoned for many years on a wrong interpretation of that law. Correcting that error is not a reason for fear or concern. It's right. It should also be a call to renew our careful consideration of the law to make sure that errors like this are prevented, or at worst, corrected.